appeal in the matter of the King on the application of Edward Becker and Chelmsford City Council.
Yes, Mr. Becker.
Morning, my lord. May it please you, I appear on behalf of the appellant in this matter, together with Mr. Clapp, who sits behind me.
Yes.
Mr. Cannon and Mr. Williams appear on behalf of the respondents. My lord, may I deal briefly with some matters of housekeeping? Because the court will have seen that unhappily there have been some fairly recent developments in relation to some of the bundles, but just to check that the court now has everything that we anticipate and hope that it should have. First of all, there should be a core bundle of 183 pages.
Certainly a core bundle. I haven't so far counted the pages, but...
Well, just from the index. Hopefully 100, and the reason I say 183 is there has been some variation over time.
Yes, that looks good.
Grateful. And then in relation to the supplemental bundle, now reduced to 350 pages, there should also be a joint authorities bundle.
Yes.
I'm grateful. And one of the issues that arose was in relation to the cross-referencing in, I think, both of the skeletons. There were some references to the old bundles. That has now been corrected on behalf of both sides by replacement skeletons that have been filed.
Yeah, unfortunately, they were filed at 5 minutes past 5 last night, which meant that they were utterly useless.
My lady, apologies for that. It was very late in the day, and therefore, if the court, to the extent the court's been inconvenienced, we're sorry for that. In an effort to try and address the lateness of that, one of the things that we did cause to be done was the preparation of a table setting out the old references and the new reference, which hopefully provides a slightly easier way into where those changes have been made.
All right, well, thank you for that.
And so, there's one other matter of housekeeping, and that relates to the contents of the core bundle, and in particular the fact that the judgment of the judge below is a draft version of the judgment. We have copies of the perfected judgment. In terms of all of the arguments that are going to be addressed to the court today, we've checked the extent to which there are any corrections to the draft, and they were very minor corrections. None of them have a bearing on what we are dealing with today, but we thought we ought to raise that now.
No, thank you. We'll work from the draft, and should anything turn on the correction of a typographical error, no doubt you or Mr. Cannon will point it out.
Well, I'm grateful. In those circumstances, then, can I turn to a brief opening of the appeal? My Lord knows that within the core bundle we have the grounds of appeal at page 14 of the bundle, and my Lord, Lord Justice Stuart-Smith granted us permission in relation to each of the 3 replacement grounds that appears at page 14 of the bundle. And therefore, the central issues that we say are before the court are threefold. Firstly, the correct construction, interpretation, or nature of the first resolution made by the local planning authority in November 2020, and essentially the question of whether that was merely in the nature of a preliminary or procedural decision to defer, or whether it was something else of a greater status. And the appellant's case is that what was happening at that stage, for reasons that were developed below and in our skeleton, is that there was active engagement by the members of the planning committee with the draft of the officer's report, and in particular the 4 reasons for refusal that were being articulated within that report. And what is necessarily implicit from the decision that was made in accordance with the defendant's constitution, the respondent's constitution that we'll come to, is that the members at that stage didn't accept the officer advice, and they therefore concluded that the reasons for refusal, 1 through 3, should not be maintained.
Why do you say it's implicit from their decision?
Because the decision to defer, which has a procedural characteristic to it, only became necessary as a result of a substantive conclusion that those reasons for refusal should not have been maintained. And the reason that must be so as a matter of logic is that if the members of the committee had voted to sustain even one of the reasons for refusal, then that would have been sufficient to refuse the planning application, and that would have been the end of the matter. There would have been no need for deferral. So we contrast that position with the position, for example, where there is a deferral because it's suggested that there's some gap in the information that has been provided to the local planning authority, and therefore there's a need to defer for that basis, or where, for example, a statutory consultee has delayed in their response, and so it's necessary for there to be a procedural delay for that reason.
But
None of those...
A deferral means a deferral. It means that they are putting off a decision one way or the other. It doesn't mean they've decided to reject and they're deferring the decision as to on what grounds they're going to accept it. A deferral means we're not deciding anything today. We're going to decide it next time.
The basis for the deferral only arises on the Constitution if the committee decide that they're not going to accept the offer.
So what? With respect, why does that make the blindest bit of difference? Whether constitutionally they might have been able to say no at that stage, they didn't say no at that stage. They said, we're neither saying yes nor no at this stage, we're minded to accept, we'll put it off to the next time and we'll make the decision then.
Yes, they weren't in a position to be able to say yes on the first occasion.
But even if you're right and they were in a position to say no, the fact is that they didn't say no at that stage. They said no the next time round. But it doesn't debar them from saying no the next time round.
Yeah, it may not debar them from saying no on the next occasion, but if they were to adhere to the consistency principle, then there was a requirement for the previous decision, given the basis upon which it must have been made, we say, for that to have been grappled with and the intellectual nettle grasped. And that arises because, as I submit, when we look at the Constitution, it is only in circumstances where the members were departing from the officer recommendation. The officer recommendation is very clear in the report, refused for the 3 reasons that are set out, and also because of the then absence of an agreement under section 106.
So if there isn't a 106 agreement, you couldn't have made a binding decision at that stage anyway.
Precisely so, and the other reason that a binding decision couldn't have been made at that stage in relation to a grant of planning permission is because of the absence of conditions, because as the court will know, when there are circumstances where officers are recommending refusal, then of course it would be not a productive use of time, and it's not done as a matter of practice for the officers to draft conditions at that stage in case there's a disagreement with the advice that they give, especially in a case like this. King's Cross provides another example where there are a large number of conditions that fall to be drafted and then potentially considered.
So, Mr. Beglan, I'm sorry to interrupt you, but just help me with this if you would, please. If a grant of permission is inevitably going to be subject to conditions, and nobody yet knows what the conditions are, how can you make a decision?
My lord, the answer to that is that one's dealing in this case with an outline planning permission, and so the issues that failed to be resolved were not those of detail relating to the layout and scale and so on. There was one matter of detail which was in relation to the access, and there's no question about that. So the points that needed to be resolved were those points of principle as to whether or not, for example, losing employment land was a satisfactory price for the local planning authority to have to pay, whether the development was in a location that was either sufficiently sustainable or whether in the balance that was struck, that was less important than the gain of housing and affordable housing and so on. It was those matters of broad principle that were for discussion at the first meeting, that were discussed at the first meeting, and that the fact of deferral tells us, the members, when they voted, and the court seen the transcript and the basis upon which the votes were carried forward, what they were voting for was the principle of the development at that stage.
Well, you'll come to that no doubt shortly, but does it really follow from what you're saying that your submission is that really the consideration of conditions was neither here nor there because the decision had already been made, whatever those conditions might turn out to be?
What had been decided at that stage necessarily was that the reasons for refusal were overcome insofar as they related to the location of the development, and therefore the matter could move on to conditions. And no one was suggesting at the first meeting that there was some need to condition the way that the highway network would work or some other element of the development in a way that could not be accommodated at a later stage. So there would need to be a discussion.
You're reading an awful lot into this resolution to say that all of a decision to defer an outcome means that the refusal, the reasons given in the planning officer's report for refusal were basically thrown to one side and couldn't be revisited.
But
that's just not right. You know perfectly well that until a planning decision is formally articulated, everything's up for grabs. They're not bound by what they said at the meeting anyway.
Well, Milady, the authorities plainly established that before the formal grant of permission, the local authority can revisit issues. But the consequence, and I say the only logical way that the deferral can be understood in these circumstances is based on a rejection of the officer advice in relation to the first three reasons for refusal, because otherwise the response is we refuse, because we accept what the officers are saying in relation to at least one of the reasons for refusal, any one of which are sufficient to dispose of the planning application.
Well, you may well be right that they could have rejected it there and then. You may well be right about that. They could have said, well, we're not prepared to consider it any further. We're going to reject it. But they didn't. They didn't reject it. That doesn't mean to say that they brushed aside the reasons for objection. What they did was they put it on ice. They even said, we're minded to accept it if we can get the right sort of section 106 and the conditions appear to be okay. But they just deferred a decision. That doesn't bind their hands in any way at all.
It may not be binding in that sense, in that it compels them at a later point in time to issue the planning permission.
No.
But what it does raise is a clear decision, we say, on the issues of principle, that if the members were then going to go back upon, they needed to confront what had happened at the first meeting and say, well, at this meeting, it was clear that the issues of principle were canvassed and dealt with, and now we're reaching a different view. North Wiltshire and the other authorities tell us that in those circumstances, so that it's clear that there is consistency and transparency in decision making, that intellectual nettle has to be grasped.
Well,
and that's what we say about it.
Mr. Begman, it may help if I just indicate where my difficulty at the moment lies. It seems to me there are two central pieces of material that you've got to deal with. The first is that the resolution didn't say have decided, the committee having decided that in principle or anything like that it would approve. it said being minded to, which to my mind, at the moment, adopting a Schumann-esque sort of way, is saying that at this moment, this is the way we're thinking. It's not the language of decision. The other document that it seems to me you've really got to deal with is 5271 and 5272 of the Constitution, because that provides for deferral where a planning committee wants to make a decision, not has done so. And so deferral comes before the decision to overturn the officer's recommendation. And at the moment, I find it quite difficult to see how with those two documents, you can say it's necessarily implicit that they have decided finally the question of whether to give permission or not.
Well, can I turn to the Constitution?
Do by all means.
And try and address my Lord's concern that way. In the supplemental bundle, page 13, we have the pages dealing with the Constitution.
Yeah.
And we know, from what appears on page 14, the need to comply with the planning code in part 5.2. And then we have the two paragraphs that my Lord referred to on page 16.
Yeah.
And so there we have provision for, if the planning committee wants to make a decision contrary to the officer's recommendation, material planning reasons for doing so shall be clearly stated, agreed and minuted. So that is what the Constitution expects to happen in a case where the members are proposing not to accept.
No, if they've got to the point of wanting to make a decision contrary.
Yes.
Which is different language from, being picky about language, but it's different language from the language of the resolution.
Well, my Lord, that's right. But in terms of what is required under the Constitution, if that stage is reached, then what ought to be happening are three things. First of all, those material planning reasons. So they have to be the reasons that the members consider are capable of overcoming the reasons for refusal, and which ought, in striking the overall planning balance, to be preferred to those reasons for refusal. And they ought to be stated, agreed, and minuted.
And is it your case that they were?
So the point about having the first set.
I think you better answer that lady's question.
I did ask a question. Is it your case that they were clearly stated, agreed, and minuted?
My
Those
lady,
reasons.
in the minutes of the first hearing, they are not set out as clearly.
So the answer is they're not clearly stated, agreed, and minuted.
My lady, what one can infer from what is contained in the minutes of the first meeting is precisely the point that there was discussion about all of the reasons for refusal, and that the upshot of those discussions was that the members were not agreeing the officer advice.
Well, that's a very convoluted way of saying the answer to my question is no. You don't get a clear statement from an inference. If they were going to make a decision contrary to the recommendation, there should have been a resolution in the minutes saying, we are going to reject the officer's recommendation for the following reasons, X, Y, and Z. They didn't do that. They said, we're going to defer.
My lady, but that's because of what comes next in the Constitution. So those material planning reasons having been set out.
Where?
My lady, I'm just for the moment reading from the Constitution.
I know, but you've got a presupposing in the Constitution that they have been clearly set out. And then certain consequences follow. But you can't say that because an application was deferred, you must infer that those reasons have been clearly set out.
My lady, there is no other basis within the materials that we have for the deferral. If the deferral is the exercise of a power by a local authority, and it has to be dealt with in a way that's reasonable and based on all the normal.
So are you saying that a local planning authority has no inherent power to put off a decision until it has further material that would enable it to take it? And you need to have that power spelled out in its constitution?
No, but what we are entitled to do, and what the court is entitled to do, is look at the reasons for the deferral in the specific case, and that's why I give the examples which did not arise here in relation to members saying, well, we need further information about a highways issue, or we need further information about the loss of employment land and what the implications of that are. And none of those matters were asked for by way of further information. So those who were present at the first meeting considered that they had a sufficient evidence base to make their decision. And what they therefore needed to do was consider whether or not they were going to refuse the planning application or whether it was going to be taken further forward. And the decision ultimately was that it would be taken further forward. And once that was the approach of the committee, then what the Constitution required them to do was to defer to the next meeting for specific reasons. And that's also consistent with the idea that at that stage, those issues of principle have been addressed, because what the purpose of the deferral is precisely so that the officers can look at conditions if they arise, and they won't always arise. It depends on what the nature of the first decision by the authority is. If, for example, the officer advice is, well, we think you should grant, and the members say, well, we disagree, and we think there should be a refusal, then the issue of conditions doesn't arise. So it's where there is a deferral and the issue of conditions arises, as it does here, and there have to be reasons given for those conditions, and that's a requirement of the regulatory framework. So we have there the reference to appropriate conditions and reasons, and the implications of such a decision to be clearly explained in the report back. So that's the part of the process that had been reached, and that's what the second report endeavours to do. We know from the internal communications that are in the emails that the court has that was the process that was being undertaken at that stage. So there was discussion about the conditions and they were agreed. There was discussion about the heads of terms that were required in the Section 106 agreement and they were agreed. And then the reporter went about putting together the report that went to the second meeting.
Mr. Beglan, what do you say about the closing words which you've just quoted? The implications of such a decision clearly explained in the report back. I mean, speaking for myself, that suggests to me that there's a clear recognition that the clear explanation of the implications of such a decision may result in a change of heart by those who were initially minded to vote in a particular way.
But the implications that may arise, again, will vary from case to case. So to take the example where there is a suggested officer refusal, and then as here, the proposed changes that we are minded to grant the permission, then at that stage, one of the implications might be, well, there's a risk of challenge later on.
Yeah.
If it's the reverse of that, and if there's going to be a refusal, then, for example, the implications might include that there is a risk of an appeal taking place. And if the evidence that the committee were disagreeing with was simply technical evidence and they had no sufficient basis for doing it, then one of the implications might be warning the committee members about the prospect of costs for unreasonable behaviour.
But doesn't all that indicate that the process of deferral plus further report, spelling out the implications, may result perfectly legitimately in a different decision?
My lord, yes, but only subject, we say, to the need to front what had been done before.
Right. Okay. All right. So, are you? I don't mean this in a challenging way. I'm just wanting to check. But I get the feeling you're rather moving away from the proposition that there was an actual decision at the first meeting, and you're really saying, although there wasn't a final decision, there was enough of a decision to engage the principle of consistency and to make it on the material here impossible in practice to come to any other conclusion.
What we accept, as we are bound to do, is that at the first meeting there wasn't a decision on the planning application because the committee weren't in a position to make a final decision on that because they didn't have, amongst other things, access to the necessary conditions. So the respondent says on a number of occasions, well, there was no decision on the application. That is right in the sense that the committee were not in a position to make that final decision. But what they were in a position to do was to make a decision as a matter of public law. And that's what they did. And the decision was to defer. And the basis of the deferral is necessarily on the reasons for refusal 1 to 3 not being accepted by the members of the committee who were then present.
What you're really submitting, seems to me, is that the resolution should have said that the committee had decided that, subject to section 106 and conditions, that permission would be granted.
Yeah.
Now, if you had that, one could easily see, and it's not difficult to draft, and obviously we're conscious of the difficulties that were being had with remote and present hearings and so on. But if you had that, you would obviously be in a much stronger position, but it highlights what the resolution actually was, which was simply that the committee was minded to approve and therefore deferred.
Yes, but
Moreover, just to pick up on my Lord's point, there's always an opportunity to correct the minutes of a meeting. And if within the time for correction, somebody who was present at the planning committee meeting had said, well, hang on a minute, the resolution that's been recorded in the draft minutes doesn't accurately reflect what we actually decided, which was that we decided we were going to reject the objections in the planning officer's report and we were going to accept the proposal in principle subject to satisfactory conditions, they would have had the opportunity to go back and get that corrected. And nobody did.
well, my lady, that's right, but one of the authorities that we have referred to, Cross, indicates that the court can look at a transcript for at least the purposes of seeking to correct what has been minuted by way of a resolution with what was actually the subject matter of the resolution, where there's a difference between the two. And so that's something that can be done even at the stage when the matter reaches the court. It's not necessary for the local planning authority to have picked up on the error that has arisen in terms of the transcription of the resolution into the minutes.
If someone had challenged this resolution, they would have gone back to what is for us page 47 of the supplementary bundle, where Mr. Roper set out his resolution,
Yes,
which was in terms, I would like to move that as the committee is minded to grant this application, further consideration be now deferred.
yes. But minded as against what is the question I pose. And it's minded as against the in principle reasons for refusal that were then in existence, because the members of the committee knew what those reasons were. They had the benefit of a detailed officer's report that set out in section 6 each one of those reasons for refusal and the detailed justification for them.
That's a scenario that occurs up and down the country every day of the week. You've got a planning officer saying one thing, the committee are not at that stage comfortable with it or think that they might go the other way. They put it on ice until they get some further information, and then they make their minds up.
But that is not, my lady, we say that is not this case.
No.
It's not deferral for the purposes of obtaining further information. What the resolution indicates on page 47, and it's almost word for word on page 47, the same motion that found its way to success, which is on page 72 of the bundle. But we have there, I would like to change the recommendation. So that's the exercise that's being gone through. The recommendation is for refusal. And I would like to move, as the committee is minded to grant the application, further consideration be now deferred so that officers may consider appropriate conditions to be imposed on a grant of this planning application and report back to the future meeting of the committee. And so what is being envisaged there is the issues of principle having been overcome. What it's necessary to do is have the conditions considered and then to see whether or not they all have a sufficient justification to be imposed, or
But
whether that's not
if the issues of principle had been overcome, there's an obligation under the Constitution to state in the minutes the reasons for rejecting them, and that didn't happen.
My lady, I say that you can collect from the minutes the fact that the balance was struck, that the overall planning balance was struck in a way that involved rejection of the officer.
And I know you say that, but you cannot infer the reasons for the rejection. You have a constitutional obligation to set out the material planning reasons for making a decision contrary to the officer's recommendation. There is nothing in these minutes that sets out the reasons for rejection. And even if you say we can logically infer that it was rejected, that hasn't happened.
If that is an answer to the appellant's case on consistency, then what that means is that in circumstances where a local planning authority, just for the purposes of the example and the argument, let's take the example where it is clear that in principle the reasons for refusal for an outline planning permission have been overcome, and what the local planning authority fails to do is record fully sufficiently the material planning reasons for doing that. In those circumstances, someone who wants to raise a consistency point is going to find themselves hamstrung by the authority's favour.
Absolutely.
But my lady, that cannot have been the way that the Constitution...
Well, they should abide by the Constitution.
But in terms of how that ought to play out, if someone has an otherwise good objection on the basis of consistency, for the local planning authority to essentially escape that by saying, well, in one respect, let's say that the...
No, you're putting the cart before the horse with respect. You only get to a consistency point if there is a properly constitutionally recorded decision to reject the planning officer's recommendations. And that can only be done in a particular way. If it's not done, you don't even get past the first post of a consistency argument. So it's the wrong way round with respect. You can't say, I've got a consistency argument, I'm being defeated by the fact that it's not been put into the resolution.
If I persist with my example just for a moment in relation to 5.2.71. Take an example where the material planning reasons have been stated and agreed, but they are not formally minuted by the local planning authority. In those circumstances, it would be a very odd result of the consistency principle for a local planning authority to say, well, we accept that we didn't look again at the material planning reasons which we had stated and agreed. But there's no fault on our part, no legal fault on our part in that respect, simply because they weren't minuted. Because the person who wants to raise the consistency point has no control in the real world over the accuracy of the minutes and what's being done there. And it's not a point that would necessarily be realised by someone who wanted to make that complaint either. So what we say is that when you look at the decision-making process that took place here, and I know I'm in conflict with my lady's approach to this, but we say there is only one logical conclusion that arises, and it comes from the fact that this was an application for outline planning permission. So it's the issues of principle about the location of the development which counted at this stage. There was a decision that the authority were minded to progress the matter further.
Your exposition of how the Constitution works for the purposes of consistency, the irreducible minimum that you need is a decision.
Yes.
I mean, that's basically what it comes to, isn't it?
Yes. And I say we have that. And
well, I think that's where this appeal stands or falls.
And so, for example, there would be no objection under the Constitution as it's written if the resolution said these matters are agreed in principle. We're minded to do it. We agree in principle that reasons 1 through 3 have been overcome. We now know that we have to progress in order to consider conditions which we haven't turned our mind to yet as a committee, and they may well raise a number of detailed issues.
Would it be sufficient to say in principle? Would it be sufficient to say in principle? Because that doesn't sound like a decision overcoming the officer's recommendation subject only to conditions in section 106.
Well, we say in principle is sufficient when you have an outline application, because it's those issues of principle that all relate. If one goes back to the officer report, what you see there is that all of the first 3 reasons for refusal turn on the physical location of this site, where it is within the authority.
Well, it's not just its physical location.
In fact, it's contrary to plan and everything.
Yeah, it's outside the development plan. It's got an adverse impact on the character and beauty of the rural area. It encroaches on an employment area. I mean, it's not just its location.
But those features are all relevant to the location. They are all matters of principle. They don't change once the details of the conditions are formulated and thought through. So they are all capable of determination at that first meeting. And if any of those matters have been determined against the application, then that would have been sufficient to refuse it.
We're going around in circles because I quite see that you might have had a situation where the committee said, well, we've looked at these objections and we decide that they can be overcome by sufficiency of conditions. So we'll minute that. We decide in principle that can be overcome. We're going to reject the planning officer's ideas, and all that needs to be done now is to draft some conditions. Now that's not this case. It might have given rise to some interesting arguments at the next stage if the conditions were then found to be unsatisfactory, or somebody produced a 106 agreement that nobody thought was good enough. And their hands would still not have been tied in, even in those circumstances. They could have changed their minds.
Well, yes, but we come back to what is our central point about all of this, which is whether all that was happening at the first meeting was a preliminary indication, as the judge described it, with only a procedural element to it, or whether there is necessarily at that stage something more, something substantive, whether or not one prefers to use the label in principle, which I say we can use. The question is, did the committee at that first meeting reach a position on those reasons for refusal so that the application could advance? And if they did, was that something that required to be dealt with and specifically addressed at the second meeting if the members of the committee were going to change their mind?
Mr. Beglan, I'm very conscious that, infuriatingly for you, we've pushed and pulled you all over the place, and you're probably a very long way away from anything you had in your structure of argument. So, in just a moment, we'll invite you to get back to your intended structure. But I think it would it would certainly help me if we just try and focus. I think what you're really saying is that there was enough of a decision at the first meeting to engage the requirements of the principle of consistency at the second meeting.
Yes.
So what would help me, it would be, please, if you could articulate precisely what it is you say was the sufficient decision or the sufficient position reached, or however you want to describe it. If you've been writing the minutes, what do you say you would have recorded to articulate that position, which is in the future going to engage the principle of consistency?
Yes, my lord, I say, first of all, what is recorded as Mr. Roper's proposed motion is sufficient, and that's page 47. And it is that further consideration, as the committee is minded to grant this application, further consideration be now deferred so that officers may consider appropriate conditions to be imposed on a grant of this planning application and report back to the future meeting of the committee. That is because it is only at that stage where in principle issues have been satisfactorily addressed as far as the members of the committee are concerned that the issue of conditions arises. If there is any remaining issue of principle, the first three reasons for refusal, and the majority of the committee vote in that way, then that is an end of the planning application.
Right. So what engages the principle of consistency at the second meeting is the committee being minded to grant the application, deferred further consideration so that officers could consider appropriate conditions and report back.
Yes, because that is a deferral for specific reasons.
Okay. All right, thank you.
And so, my lord, but perhaps if we stay with the transcript just while we're there and look at some of the other key references. The members of the court will have considered this carefully, and so I don't propose to go through all of the detail within the transcript. But if we look, for example, at page 48, just to get the flavour of the consistency of what's happening during the course of this meeting, we have Mr. Mayfield, the entry just above the foot of the page. Yes, Chair, thank you. Members, just to be clear, the motion from Councillor Roper is to approve the application, and that if it is approved, be brought back to a future meeting to decide the conditions to be attached to the Planning Commission. And then we have the Chair of the Planning Committee saying, correct, yes. And the other sentiments that come from members of the committee at later stages are entirely consistent with that. So if, for example, we look at page 62, we have again the chair of the committee, in light of some of the difficulties that have been arising, making this suggestion. Would it be a good idea to say either we approve or refuse the application, rather than saying for or against? It may have confused someone. Would that work if we say approve or refuse the application? Mr. Mayfield, the officer, we could try it that way. Mr. Roper wants to put his resolution again, and he says towards the foot of that page that you'll get a positive or a negative answer on that. It's for approval, so you you either approve it or you disapprove. You'll vote against it. We see the legal advisor, Victoria Marsh, page 66. Again, towards the foot of that page. Third entry up from the bottom. I think perhaps we should vote slightly differently and go with the suggestion to say either that you're wanting to refuse or approve. I think that's a lot clearer because I think it has caused some confusion. And so there is, to consider the authorities that we say allow a level of reference to the transcript by looking at the overall tenor of the meeting and being careful not to pick out isolated phrases. When one looks at the tenor of the meeting, we see that there is consistency across essentially all of those who had spoken, that what was, as it were, up for discussion and decision here was whether or not there was to be approval or refusal. And then if the will of the committee is for approval, necessarily there has to be a deferral so that the issue of planning conditions in the section 106...
Well, Victoria Marsh is, you say, is the legal advisor.
Yes.
Her intervention on page 66 brings them back to the Constitution, doesn't it? Wanting. So the passages before one could see as suggesting there's actual, supporting an inference that there was an actual decision to approve the application. You'd have to write in all the qualifications. Victoria Marsh brings them back to the Constitution, which is that they're in a position of wanting to.
Yes.
And then Janetta Sozin says, fine, I'm happy with that. I hope I haven't caused anyone offence by mispronouncing their name.
The reason for that formulation of words is precisely because, as we accept, there can't be an approval of the application in a formal sense during that first meeting for precisely the reasons that require deferment. So the reference to wanting to refuse or approve is the critical decision at that stage. The members of the committee aren't in a position, even if they wanted to advance the matter further than that at that point in time. But all I say...
But that's your problem, isn't it? They're not in a position to make a decision. It has to go off until they've got more information. So even if you could say it's bound up with section 106 and the conditions, they're not making a decision, except to defer.
My lord, that's where my submission parts ways, as it were, with the present thinking of the court, because I say that there is a public decision there, and it's that decision that engages the deferral. In the absence of that decision, there's no deferral. Nothing has happened at that stage. So there has to be a trigger.
That's basically saying that the only circumstances in which you can defer consideration is if you've already agreed in principle that you're going to accept you're going to approve and reject what the planning officer says, and that's not right. You could reject what the planning officer says, and you'd expect them to do that in a separate resolution, giving their reasons under the Constitution, but they didn't do that. There was a certain amount of toing and froing in the passage between page 51 and 66, where first of all the chair uses her casting vote to resolve a deadlock against granting the application. Then they had another vote on the contrary and got completely the opposite result. Everybody got into a twist about it, and the legal advisor intervened and said, look, let's see if we can sort this out. But that doesn't really take us much further than the resolution itself, it seems to me.
The only further point that it assists with is the interpretation of the resolution, insofar as there is a need to interpret what minded to means in these circumstances. My submission is minded to is there, or wants to is there, because that is the furthest stage that the committee can get to in the absence of formulated conditions. And that I say is consistent, one, with the resolution, two, with the tenor of the debate that took place during the meeting. And so just to pick up perhaps on one or two more references, if we go to page 71 of the transcript, we have Mr. Holmes again.
Sorry, which page?
Sorry, my lord, page 71.
71, thank you.
Second entry on that page, dealing with the nature of the decision to be made. And he speaks about recommendations in whatever form. Then, in effect, that's going to defer the application to a subsequent meeting of the committee. It won't refuse it, as you know from the Code of Conduct, because the committee can't make an actual decision to refuse it on the night without agreeing the conditions. So all I was going to suggest is that it doesn't matter which way you do it.
Well, with respect to Mr. Holmes, when he says refuse, he means grant, doesn't he?
Yes, that's because of the way that the resolution had been being turned around, but it's absolutely clear that that is what he meant in substance.
Yes.
And so it carries on. I think you would need to have a clear understanding of members' wishes and how they want to vote, and then we will either defer the application to come back with conditions and things like that. So things of a similar category to conditions, like the Section 106, which also need to be addressed, or it will agree the officer's recommendation. So those are the two alternatives at that stage. And there isn't a third alternative in circumstances where no one is suggesting a deferral for other reasons that might apply in a different case. And so that's what leads to the motion being put again on page 72.
Right.
And we have the reference to appropriate conditions to be imposed on a grant of planning application. And that motion, as ultimately voted on in favour by the committee, is subtly different to the way that it was formulated within the minutes, but different in a way that was ultimately important to the judge when she considered how to approach the resolution itself. And so, well, that's what I wanted to take from the transcript of the first meeting. But
Right.
so that I can perhaps address some of the issues relating to the principle of matters, which is where the court isn't minded to accept that the principles were subject to being decided at that stage. Can we look at the officer report to the first meeting for that purpose? And that's, so we're back in the core bundle. At page 165. On the following page, the report has a helpful executive summary, which sets out the nature of the proposal, the fact that it's in outline at paragraph 1.3, with access to be considered, and then speaks about the conflicts with policy that are identified within the report. So first of all, we have the fact that the development would remove the employment provision at the site contrary to DM4. So that's identified as a matter that relates to location and principle. Then at paragraph 1.4, residential development of the site would be harmful to the intrinsic character and beauty of the countryside, contrary to policy DM8. The third matter that is raised is the said to be unsustainable location for the reasons that are given in paragraph 1.5. Again, self-evidently a matter relating to principle and location. And therefore, 1.6 overall, contrary to the Council's spatial strategy, so that matter of strategy and principle, which seeks to direct growth in those sustainable locations, the application is therefore recommended for refusal. And there's more detail in sections 2 through to 5 about the background history and the consultation responses, but then entirely consistent with what's said in the executive summary in section 1, we have that being fleshed out in section 6, where the issues are taken in turns. And again, the court will have read the report, and so it's in most examples, in fact, probably in all the examples, the final paragraph of each of the sections that contains the policy conflict. So if we look, for example, at rural employment area on page 169, starting at paragraph 6.3, and the reasoning is developed, and then at paragraph 6.15, the conclusion that we see set out in the executive summary. Countryside comes next, with the conclusion being set out in paragraph 6.21. Then after that, spatial strategy, and the conclusion there, 6.29, in relation to a location said to be inaccessible, and then other issues identified which did not become reasons for refusal. Then we have the section 106 agreement being discussed before the officer gets to the planning balance set out on page 174, and then the reasons for refusal follow. And so it's all of those considerations of principle that I say were in front of the committee at the first meeting, that were debated by them, and where conclusions were reached. And if we pause to consider what a conclusion that there was, for the appellant's purposes, really no decision of any note at that first meeting. What that means is that for an officer, for a member who, for example, has read the papers in preparation for the meeting, in an ordinary case, perhaps gone on a site view. Here we know that in fact, because it was still times where the meetings were being dealt with by teams, there was a run through by use of video in relation to the site. The member will listen to the presentation, hear about the issues of principle, hear the presentations by various individuals that are often done and that we know were done here. They will have discussed the detail of the proposal amongst themselves and considered to what extent there could be a form of resolution and then voted on it. If one just considers all of those preparatory steps that take place before any form of conclusion happens at the first meeting, and then perhaps rhetorically asked, well, if a member who was present at that first meeting, but through illness or other commitments couldn't be present at the second meeting, if they were told that everything that had happened at that first meeting was essentially of no legal effect, they might find that a surprising conclusion. We say that
it was legal effect because it led to the resolution and the deferment.
Yeah.
But what's being said is that for that member who's not present on the second occasion, their colleagues who are present on the second occasion need effectively pay no mind to what has happened on the first occasion. There's no issue in relation to the principle of consistency. They are free to simply say, we disagree, without more.
Yeah, they can. I mean, they're not going to forget what happened at the first meeting. They will have it well in mind, but they're not bound by it.
And they may not be bound by it, and they may well not have forgotten it. Certainly, the members of the second meeting were reminded.
They were reminded expressly
reminded
of what had happened before.
They were in this case, but even taking matters in the general run of things, I accept both of those things. But what that doesn't address is the need for a level of regard to actually be paid to what had already happened within the decision-making process in circumstances where there has been a decision which allows the deferral to take place for specific purposes. I accept, as would be clear, that if there was no substantive discussion on the reasons for refusal, very early on, there is an identification of some difficulty in the information that's been provided to the committee, some incompleteness, and that there is a deferral for those reasons, then the principle of consistency plainly could not arise. It would have nothing to attach to. But here, my submission is that it does have something to attach to.
Where I am at the moment struggling is to find anywhere in the first minutes or in the transcript even anybody, let alone a majority, articulating the reasons for overcoming the planning officer's objections.
My lady, that is...
If they had decided to reject the planning officer's recommendation, you'd expect them to explain why. And they never do.
My lady, it would have been a much better use of the local planning authorities' resources if they had recorded expressly, we are disagreeing with the officer advice at this stage, and this is why.
Well, even if they'd said why in the course of the transcript, it might have given us a bit of a steer. But you see, you're asking us to infer that they rejected the recommendations without in any way, formally or informally, articulating why, which is contrary to the Constitution, and that this somehow engages a principle of consistency, which means that they've got to go back to consider reasons they didn't articulate and overcome them in order to come up with a contrary decision. And I find that rather fanciful, I must say.
There are articulations as the debate progresses from individual members.
Yes, but there's not a consistent articulation by the majority in any form of resolution or any kind of decision that one can carry forward, whether it's minuted or not.
There is a consistency and a tenor in the meeting of the various members of the committee seeing the benefits that this proposal would provide, coming to the meeting as they must be taken to have done, with the benefit of having read the officer's report, seeing what the essence of the proposed reasons for refusal are, and then through their respective contributions to the debate, disagreeing with the notion that those reasons for refusal should carry the day, and the reason necessarily why those reasons for refusal don't carry the day is because of material planning reasons, the ones that were identified here. And there is a consistency, I say, in what members of the committee said individually, is in relation to the provision of housing, because that's the benefit of this scheme. That's what it brings. And so, insofar as one's weighing the planning benefits against the disbenefits are identified by the officer. The benefits lie in relation to the housing and the corollaries benefits that that brings, the employment in relation to those who are constructing houses, preparing the ground, and so on. But the key benefit is in the housing, and potentially in relation to provision of affordable housing as well. So it's not a case where, in terms of trying to analyse the tenor of the meeting, that there are potentially a large raft. It's not, for example, a mixed-use scheme where you might have various different components of a mixed use, and members of the committee might think quite differently about the benefits of various components of the mixed use. Here is a straightforward housing proposal, and so insofar as the members of the committee are minded to think that there are benefits that outweigh the identified harms, they are through the provision of housing. And of course it would have been better if that had been expressly articulated. But again, in terms of what must have been happening in this decision-making process, there's no other substantial benefit to the scheme that is identified because of its nature.
But it's not it's not simply a question, well, shall we build a house on this plot of land or shall we not? Here, as I understand it, and you correct me if I'm wrong, their own local plan would be opposed to the development of 55 odd houses in this location. So it's not so to speak a simple choice to build or not to build. It's to build despite our own plan saying the exact opposite, or not to build.
Yes, but the plan makes that provision for the retention of employment land within certain spaces, and that's part of the reasons for refusal. So all of the members who come to the debate know that that is an important part of the officer's reasoning, and it is therefore necessarily so that for those members who express a view in favour of the proposal, that the benefits of the housing development overall are enough to overcome, amongst other things, that designation.
All right. Well, I don't, as I've said, want to take you out of your preferred course, but I wonder if we're getting to a stage where you might want to turn to what you say didn't happen at the second meeting, which had to happen if the eventual resolution of the second meeting was going to be a lawful one.
Yeah. My Lord, could I do that first of all by reference, and I don't propose to necessarily turn them up individually unless that's going to be of assistance now, because the principle of consistency, if it applies here, is a well-established principle. And so, for example, what we see if we consider the cases are a few matters. First of all, that where the obligation of consistency arises, it leads to twin requirements, both of which have to be met in order to satisfy the need for consistent decision making. First of all, the authority on the second occasion has to give a reason for the departure from the earlier decision. And secondly, in doing that, it has to have regard to the importance of consistency in its own right. And you can take that from, amongst other authorities, the St Albans case at tab 3, North Wiltshire at tab 4, and the Thompson case at tab 16. And I can provide the court with individual references if the detail is helpful. But I say those are the twin requirements that are imposed by the consistency principle. The second observation I would make about the consistency principle, and this is important, or at least relevant to the way that the judge approached it, is that the consistency cases involve both large projects, so there's the King's Cross case, and then the St Albans case as well, but they also involve small projects, such as the single units in Dunster properties at tab 14. So it's not a principle that is confined to substantial projects. The third observation I make is that in relation to what is required to satisfy those twin requirements, and perhaps in particular to the need to have regard to the importance of consistency, it is not enough for a decision maker at the second stage to simply say, or for it to be implied that they would have said, I disagree with what my colleague, whether it's an inspector or members of the planning committee, did on a previous occasion. And again, you can pick that up from the St Albans case at tab 3, paragraphs 31 through 33, or you can see it in Dunster properties on a smaller scale at tab 14, paragraphs 14, 19 and 21 to 23. And so that is what I say the obligations of the consistency principle require. And so following that through to what happened at the second meeting here. What we know is that there was no, or my submission is, there was no clear reason given for departure. And here, the point that arises is that that reason would need to have been expressed in the minutes as part of the record, part of the reasons for the decision-making process. Similarly, the fact that regard has been had to the importance of consistency would need to be expressed in the reasons for the decision-making themselves, and you can find that from each of the authorities that I've referred to on this topic. And that does not happen in this case. The extent of the reasoning that is provided is by reference to the decision that the application should be refused for the reasons in the first report. In framing the decision in that way, the officers and members necessarily did not record reasons for what had occurred since the date of the generation of that report, in particular what had occurred at the first committee meeting.
But isn't a reasonably benevolent interpretation of that to say that what that means is that despite what has happened since, the committee on this occasion are satisfied and adopt the reasons of the first report?
Well, that is what they did, but what that doesn't...
What's wrong with that?
Well, what that doesn't overcome is what I say are the twin requirements of meeting the consistency principle where it arises. And that is...
what they should have said is, despite what's happened in the interim, which includes the fact that we were minded initially to grant planning permission subject to conditions, we've changed our minds about that, and we are now persuaded that the officer's report gives us powerful reasons for dissenting.
That would be the first part of the necessary reasoning. The second part would be to pay heed in itself to the importance of the obligation of consistency.
Well, how do you do that? How do you do that in this situation? You add a few words which say, and we know that we should really stick to our guns, but actually, having thought about it further, we're not going to.
It needs to, if they're going to be good reasons of public law, then they need to address squarely the point about the previous decision and explain why the members of the committee on the second occasion nevertheless thought it was the right thing to do to reach a different conclusion, bearing in mind what their colleagues had previously decided. And that's what is missing. And if the consistency principle is to have importance and effect, then those kinds of issues do require to be addressed within the reasoning in the subsequent stages of the decision-making process. Otherwise, how would anyone who wanted to test that later report to see if it did in fact comply with the duties, how would they be able to do it? That they would be driven back to the idea that there is implicitly and necessarily a disagreement with what their colleagues had previously done. And that is why perhaps the authorities are careful to say that it is not enough to say, I disagree. There has to be a more reasoned response which takes up the importance of the consistency principle.
Just looking at page 97 in the supplemental bundle, the transcript of the second meeting. Right at the outset, the chair says in the second paragraph, firstly, as the report makes clear, no formal decision was made. That's the normal process. It was minded to approve all options remain open to the committee. Do you accept from that that the committee on the second occasion did not, as it were, regard themselves as making a contradictory decision? They regarded themselves as not yet having made a decision? Or do you say there's something later in the transcript which shows that they were consciously operating in an environment where consistency was important, but were wrongly failing to meet the requirements you've identified?
The latter. And so the consequence of the report having that statement in its early passages is in fact to compound the problem, because what occurs is a suggestion that without more, all of the options remain on the table, and there is no need to pay any.
I'm sorry, I didn't make myself clear. I understand your submissions on the point. I'm just asking whether you make any point about what the committee thought they were doing. And on the face of it, the chair makes it very plain. We haven't made a decision yet, or all options are open. Now, who wants to open the debate?
Yes, but that would be superimposing, as it were, the chair's view about it.
Right. Well, is there something later on where somebody says, well, obviously, we're now going back on what we decided previously? Does anybody say that anywhere in this transcript?
There are references to minds being changed. You can pick that up, for example.
That's not quite the same.
It isn't quite the same, is it?
In fact, it's not even nearly the same.
That's, as it were, within the transcript, as close as it gets.
Okay.
But my point about that is that doesn't help the local planning authority. That compounds the problem.
Yeah, I understand the argument. I just was just curious to know what you say was actually happening, or rather what the members thought they were doing.
It's a bit curious, isn't it? If they all thought they'd reached a decision to reject the planning officer's recommendations on the first occasion, and the chair said, well, you have all options are open, you haven't decided anything yet, you'd expect at least one person to put their head above the parapet and say, well, hang on, we made a decision in principle last time, we were going to reject the recommendations. All we're talking about is what the terms and conditions are. If they don't do it, doesn't that rather strengthen the respondent's case and what way that the judge looked at it?
My lady, I say no, because it's that requires the members of the committee then speaking to have identified for themselves the importance of being consistent with what they have previously done. And there's
with respect, it doesn't. It involves somebody who comes to the meeting, a layperson, not thinking about consistency or principles or legal matters. You're a councillor. You come to the meeting and you think you've decided something. You think that this option's off the table. The chairman says the option's on the table. Surely, as a matter of common sense, you'd say, well, hang on, Chair, I thought this was no longer up for grabs.
That thought was not articulated
by anybody.
Well, and in particular, not by those who still, as we see from the transcript, were minded to vote in favour of the proposal. Yes, but that...
So they don't turn around to their colleagues and say, well, hang on, Mr Snooks, you can't turn around and decide this against, because that ship has sailed.
But, my lady, that rather assumes that the individual councillors in question are going to disagree with what they've been told in the officer report, and those councillors who read the officer report will know that it's been prepared, or will assume that it's been prepared with the benefit of legal advice and that it's legally correct. And therefore, on that basis, a councillor who comes with their planning experience but who doesn't come with an understanding of the principle of consistency quite what the Constitution, what the niceties of the Constitution are. It's not as surprising as one might think if an individual member of the committee doesn't raise the point in that way.
Well,
Can I just ask you something? A very, very basic question. If you go to page 71 of the core bundle, you have paragraph 34 of the judgment.
Yes.
And we can take the first 6 lines down to the words preliminary view. Do you accept that if that is upheld, which is essentially ground 1, then your ground 2 cannot succeed?
Well, Lord, in substance, I do. Yes.
But that was my view when I gave you permission, that they stand or fall together.
Yes.
And so really, what this appeal is really all about is the first 6 lines of 34.
Well, Lord, I accept that. In relation to what's said there, if I move,
We've got your submission. I didn't want to pull you right out of your thing. Do go there if you want to, but I just wanted to be clear, because we were talking about ground 2, what the premise is.
well, Lord, if I perhaps turn to the judge's judgment, I'll explain what I say the consistency principle entails and why, if it was engaged, it wasn't complied with by the local planning authority in this case. And we have the judge's discussion at page 70 of the bundle, starting with the decision at the first meeting. And just to note, the resolution, as recorded by the judge at 33, is not, and the court will make the comparison, is not Councillor Roby's motion as voted upon and as agreed by the members. And I have referred to the case of Cross. I say, insofar as there is a distinction between the two of them, then what ought to have been under consideration is the term of the resolution as voted upon at committee, not as necessarily.
Is the difference material?
But, my Lord, the difference is material, because if we look at the way that the judge dealt with the construction, the judge refers to the particular way that the resolution was framed and emphasises the presence of the word could, and that it would attach to any planning permission. And the formulation that Councillor Roby used was different, and it was that the matter should be deferred for the consideration of conditions to be imposed on this application. And he uses the formulation this application the first time round, and then on the second occasion the word this disappears according to the transcript, but it's otherwise materially identical.
Also, as ultimately voted on, it's page 48 of the supplemental bundle. Is it?
No, my Lord, it's apart from one word, it's the same, but it's 73 that formally, sorry, 72 in fact. Supplemental bundle, page 72, top of that page.
May consider appropriate conditions to be imposed on a grant of planning permission, as opposed to any grant of planning permission.
Yes.
So the difference is between the word a and the word any.
Well, and the reference to could as well, which is what features within the minutes.
Where is could?
If my lady turns to page 71 of the core bundle, paragraph 34, the wording of the resolution at the
Yeah, I'm just
end.
looking at the resolution. respect. Oh, that could be attached.
Yes, to any grant. And the judge has underlined both of those words as being of importance to the judge's construction of the issue. And I do say that what appears in the transcript itself is different in a way that is material.
And so you are, do you say that the motion is as set out at the top of page 72?
Yes.
Full stop.
Full stop. And cross is an example in the authorities where a similar problem had arisen, where the minutes didn't actually accurately reflect the resolution, and the judge in that case went back to the wording of the resolution. And so then, turning to the judge's approach in relation to the decision at the first meeting, we can note first of all that after the judge sets out the resolution that was passed, she gives her assessment of the meaning of the resolution, and our submission is that that happens before there is consideration of the transcript and what the transcript might offer by way of supplement or enrichment of that understanding. And the reason that we say that is that paragraph 34, which contains a conclusion on the meaning of the resolution, ends without there being any discussion of the transcript. And it's at that stage that the judge has, for the first time, I think, expressed the idea that this is a preliminary view of the authority.
Was the point taken below that the minutes were inaccurate?
My lady, no, there wasn't the focus on the precise.
Well, I'm wondering to what extent it's open to you to argue that now, if it wasn't a point before the judge. I mean, if the case below proceeded on the basis that the resolution was an accurate reflection of what was agreed at the meeting, how can you now turn round to us and say, well, it wasn't, and we can use the cross principle to look at what was decided in the transcript?
Well, my lady, I say that's a point that's open to me on arguing grounds 1 and 2.
But how can the judge be criticised for dealing with the matter in the way in which it was presented to her? We can only interfere with the judge's decision if it was plainly wrong. But you can't say the judge was wrong if she wasn't. If you're trying to raise an argument that she didn't consider.
Well, my lady, I say that the error that potentially arises here is in relation to the objective ascertainment of what the resolution meant, which is a question that's open to this court. And this court, in those circumstances, can look to all of the circumstances to see what assists in ascertaining the true meaning of the resolution.
We can certainly look at what the resolution as recorded means. Speaking for myself, I'm not sure that it's open to us to say that the resolution was inaccurate and look at the transcript.
My lady, I say that that's a matter, bearing in mind that the way that the judge formulated her reasons and the focus that was put upon the specific form of the resolution, which wasn't necessarily subject to the same level of attention below, but it obviously commended itself to the judge when she gave her judgment.
Well, yes, but I mean, she's not to be faulted for that. It's the way the case was presented to her. A judge can only operate on the basis of the arguments that are put before them, and you're now seeking to criticise Mrs Justice Thornton for referring to the words could be and any on the basis that could be and any are subtly but materially different from what was actually resolved. But that was not a matter she ever had to consider.
I'm inviting this court to a different conclusion on that issue, recognising that what the court will be concerned to achieve is the proper understanding of what the actual resolution that was made by the authority was.
Well, you were starting to submit, Mr. Beglan, that the judge reached the conclusion at paragraph 34 before considering what light the transcript might shed on it.
Yes.
Did you want to develop that submission?
My Lord, I will. I'm grateful. One of the things that perhaps indicates that the judge here had formed a conclusion independently if our construction of the judgment is right, and that therefore what may or may not have been said in the transcript by way of a different form of resolution would not have influenced the judge's conclusion.
But she dealt with it in 35. It's bang next door.
Well, it's bang next door in the sense that it follows after,
But it's clearly part of her reasoning, isn't it, for her ultimate conclusion?
My Lord, I say that depends on how the paragraphs are expressed. The judge has chosen to express herself by starting paragraph 34. In my assessment, the meaning of the resolution makes clear, and we see what's taken into account in that paragraph, and there is no reference to the transcript there. But then we see the way that the judge deals with the transcripts as well, which I say is also relevant to trying to ascertain how much weight or otherwise the judge placed on the points that were made about the transcript. And the judge addresses this, as my Lord says in paragraph 35. The claimant took the court through the transcript of the meeting and pointed to excerpts which it was said. So that's recording the submission made to the judge rather than the judge's view about the matter. Although it's right to observe that the judge doesn't later disagree with what follows, but it's being characterised as a submission made to the judge. That showed clearly that councillors, the chair of the committee, its legal advisor and senior planning officer all approached the discussion on the basis that is there set out. The committee was deciding whether to approve the application or not. And then the judge deals with that submission, which is a summary, but accurate, but summary form of the discussion of the transcript that took place at the hearing below. In this way, the judge says, however, the transcript of the meeting cannot usurp the committee's resolution for the reasons explained in BB. So that the way that the judge addresses the force or otherwise of the transcript is to say, well, that certainly can't in any way usurp what's been dealt with by the resolution, and therefore I'll, as it were, park that there. And then the judge moves on to a slightly different take on BB, which is to say that the confusion that had arisen in the committee on the first occasion is perhaps an indicator of the cautionary remarks that were made in BB in relation to how you might treat a transcript. But then the judge recognises by the end of that section that at the end of the meeting the confusion had been resolved, and we see what the advice of the head of democratic management that's recorded is.
Well, that all makes perfect sense to me in the context of an argument being put to the judge, that you have to look at the wording of the resolution as recorded and construe it against the fact that everybody thought that they were deciding whether to approve the application or not, which appears to be the way in which it was argued below, rather than that the resolution was inaccurately recorded. Because everything that she says makes complete sense if you look at it in the light of the way in which it was argued.
My lady, what I say about the way that the transcript is addressed is that the judge doesn't analyse the various passages that the judge was taken to below, and I've given some indication of some of the passages to this court and address those on were their merits and say, well, does this indicate the tenor of the meeting? Does this indicate that the tenor of the meeting which led to the resolution may have been subtly different from the idea of there being a straightforward deferral? Because that's the way that the judge is approaching it.
Whatever was said beforehand, ultimately what happened was that certain advice was given and they decided to defer it. I can't see myself what's wrong with that.
Because what that doesn't take up is whether or not the transcript provides assistance with what was lying behind the deferral.
Well, she says it doesn't.
Sorry, my lady, I missed
She
that.
says it doesn't. She says the transcript doesn't really help because what you see is a certain degree of confusion between members about what they're deciding to do, but ultimately it's resolved. She quotes the relevant part of the transcript as to what they were advised, and then she says they approved the resolution to defer.
Yes, but what I say about that is that the references that I took the court to earlier demonstrate the tenor of what was happening within the first meeting, and the tenor of that discussion shows the nature of the purpose of the deferral. So it's not a deferral simply based on a preliminary view or for some other reason relating to inadequate provision of information. It is on the basis of various members of the committee, the chair of the committee and others, saying, look, the essentially binary choice before us at this point in time, knowing that we don't have the information we would need to formally approve the planning application, is to decide whether, as matters stand, we approve so that it goes forward to the next stage, or we refuse it. And that is the contrast that is used in the language. And so it's on that basis that we say that the committee's decision did not pay adequate regard to the principle of consistency. And when the judge was analysing the issues relating to what the nature of the resolution was, and indeed the importance of consistency here, those difficulties were not explained or not met by the judge's reasoning, because in relation to the discussion of the Constitution and what follows later on, we see, for example, at paragraph 39 on page 73, that in addressing the Constitution, the judge concludes that the function of the Constitution here is to provide, this is the last sentence on paragraph 39, a pause or a breathing space in the decision making. And my submission is that that is not the purpose of what the Constitution is providing. What the Constitution is addressing is that in the circumstances where there is a member overall of officers' advice to refuse, there will not be conditions. It's highly unlikely that Section 106 will have been prepared. And so that's why there is the need to defer in the way that the Council has expressed it during the course of the first.
But this really takes us back, Mr. Beglan, if I may say so, to what I asked you about much earlier in this hearing. The words, I can't quote them verbatim, but to consider the implications of such a decision. Isn't that precisely requiring a planning committee to think twice before they go behind the recommendation of the inspector? It doesn't forbid them from doing it, but it sets up a mechanism, the practical effect of which is that whatever you were minded to do first time round, before you actually make that decision, just bear in mind this is what you're doing. ... And is that not fairly described as a pause or breathing space in the decision making?
Well, no, I say that what the Constitution has in contemplation when it makes that reference to implication needs to be read together with the words that immediately precede it. And so what is happening is a deferral for specific circumstances, and then for any implications that arise from those specific circumstances to be spelt out and addressed as necessary at the second reporting stage. So I gave some examples of that earlier in relation to the risk of challenge and needing to deal with that, the potential.
That's a very narrow reading. It's the implications of the decision must mean the implications generally, not whether it might be challenged by one mechanism or another. Of course, inevitably, if you make a decision that's going to upset some sector of the public, they may challenge it either by way of judicial review or by any other mechanism. But the implications are the planning implications, surely, of the decision. The wider planning implications must be included in those words.
My lady, if, for example, what was intended by this provision of the Constitution was that there would be reconsideration or potentially revisiting previous decisions, then that could have been spelt out in a way that would be far more express, rather than seeing, as we do within the Constitution, this reference to implications at the end of a sentence that is dealing with matters that are secondary to the issues of principle that may arise on a planning application. So it's when those issues of principle, I say, have been overcome, that what the Constitution invites attention to are consideration of issues like the conditions, like the ancillary things that go along with that, like, for example, whether or not the conditions can adequately address the points that they need to in relation to a development for 44 dwellings. So to give an example of what happened here at the second meeting, there was a vote and a suggestion that in fact the conditions weren't good enough, essentially. But what you won't find within the transcript of the second meeting is any specific discussion as to why that is so. So that's an example of an implication. Something could come forward through the conditions which could be considered, in the event, to not be sufficient to meet.
I haven't interrupted you yet, Mr. Pickett.
It was
unusually for this morning.
I had the sense that it might be.
Yeah, there's something coming, but finish your sentence first.
I'm grateful. My lord, forgive me. The conditions are one example of something that is yet to be discussed at the first meeting, necessarily. And so when those conditions come to be formulated, we see that there are 19 of them here. There's often matters of considerable detail and importance that may need to be dealt with by way of conditions. At that stage, there may be additional implications that arise that can perfectly properly be the subject of discussion. What may happen as a result of a decision being taken forward can be an implication of that, and it's not unusual, as the court will know, for precisely those kinds of matters to be articulated in a report, the risk of challenge if a decision is made against officer advice. So these are not, as it were, unusual examples of what might come up by way of implications. What I submit is that the presence of the word implications at basically the end of this passage of provisions dealing with the Constitution doesn't indicate something as fundamental as a freestanding constitutional suggestion that just because there's been a departure from officer advice at an earlier stage when different issues may have been in play, that somehow is all to be looked at afresh. If that were to be so, then rather than implications, what one might expect to see reference to is reconsideration, review, some language of that nature.
Thank you.
Does that?
Well, it's another very basic question, but it's niggling away at me. How could a committee decide to overrule an officer's recommendation to refuse, even in principle, without having sight of conditions?
Because when you're dealing with an outline planning permission, or indeed with another kind of permission, what decision makers will commonly look at is whether or not something can be made acceptable by conditions. And one of the basic principles in planning decision making is that if something can, which on the face of it appears potentially objectionable, can be made acceptable by the imposition of planning conditions, then permission should be granted subject to those conditions that are necessary to make it acceptable. So when you're dealing with an outline permission, and that's why I do say that it's fundamental to understanding what was occurring in this case, to look at the fact that it was an outline permission and therefore the nature of the issues that were thrown up for discussion at the first committee meeting. When one approaches it through that lens, then it was open to the members of the committee to reach an in-principle conclusion that the location wasn't unsustainable or wasn't sufficiently unsustainable, bearing in mind the housing benefits that were going to be provided, wasn't so in conflict with either the spatial strategy or the generalised need to protect employment land that the proposal shouldn't proceed. Those kinds of questions were capable of resolution at that stage.
I can see why you say that, because if the fact that it's an outline permission is really what makes your case. If it wasn't, I think you really wouldn't be able to advance it at all. But there are a number of possibilities. One is that the officer makes a recommendation against, and everybody looks at it and says, whatever conditions you might attach to this, this is hopeless. It's an eyesore, it's a blot on the landscape, we're not going to go ahead. And they would resolve to do it then and there, and they could do that. But there may be circumstances in which there is an open mind about it. Well, you know, we might be able to get away with it if we landscape it in a particular way, or we require them to build it to a certain level, or we put it in nice Cotswold stone, or whatever it may be. But we'll just have to wait and see what those conditions are, and depending on what is recommended and what sort of things are practically possible to achieve, then we can decide one way or the other. Now they're parking it. I'm not saying one way or the other what they're going to do, but if the conditions come back and then somebody thinks, well, no, I'm not happy with that, they can still say no, can't they?
Yes, on the basis of the conditions being unsatisfactory.
Oh, I see. So it's only if the conditions are unsatisfactory that they can change their minds, but they can't make a difference. They can't take a different view without there being a material change of circumstances.
In my lady's example, what doesn't arise is the issue of consistency, because what is happening is that one's moving on to the next stage of the process, about which there hasn't been a decision
Right.
at the first stage. That's the distinction that I draw.
Right.
And as my lady will know, from most of the examples that were given in relation to design or how matters ought to proceed, then quite often a condition will provide for the production of a scheme to the local planning authority for it to agree that scheme. And so it remains within the control of the local planning authority at that stage. If the scheme can't be agreed, the matter won't go forward.
Yeah. Yes.
All right. Is that really bringing us towards the end of ground 2, Mr. Bigland?
My lord, it is.
Do you want to take a moment? You've been very patient, but I am conscious that you really have been taken quite a long way out of whatever course you might have set yourself at the start of the morning. Do you want to should we just rise for 2 minutes to let you gather your thoughts?
My lord, I'm grateful, but I'm content to continue.
You're happy to press on.
One ends up by one route or another, going with similar material
Yes.
in any event. But I suspect the only further point I would make in relation to ground 2 is the point that the court has in terms of how our submission is framed. But if the principle of consistency was in engaged, we say here that because of the way that the second meeting took place and the way that the resolution required refusal for the reasons in the first officer report, the upshot of that is that no weight is given at all, no status is given in terms of formal reasoning in relation to the decision that we say was made in the first meeting. And that's important because potentially the twin goals of the consistency principle could have been met, but we say they weren't met here. Well, all that leaves the issue in relation to ground 3, in relation to appearance of bias or a closed mind. And the court will have seen that I was granted permission on that ground, but in a more circumspect way, if I might put it that way. But nevertheless, in developing that ground briefly, the court will have seen the various features that are set out in the statement of facts and grounds, and so that's where I refer to 12 features that I say are important here. And the way that we characterise the submission, the reason that we say that those factors are particularly important here is because of the business that we say was most properly the business of the committee on the second occasion, when it was, at least principally, to look at the issues of conditions, to look at the issue of the Section 106, and to do that against the backdrop of circumstances where the conditions have been agreed as between the professionals and the heads of terms of the Section 106 agreement have been agreed as between the professionals. And so in relation to both of those issues, of course it was open to the members to raise specific concerns, notwithstanding the professional agreement on those issues. But perhaps when one looks at the transcript of the second meeting and sees that there is no articulated concern with any one of the conditions, and certainly not a suggestion that would not be potentially capable of being overcome by an agreed scheme, to use that example again, then what we say is that the almost immediate movement back to the principle of the development and what was under discussion at the first meeting is an indicator of a closed mind as to the business that was actually properly before the committee at that stage. And we say that's an important part of the lens through which to see the argument about closed minds. The other important feature about that is the way that the report was prepared. And again, the court will have the benefit of Mr. Hopkins' analysis of that in his second witness statement and the emails that have been set out within that, as well as the table which sets out the 6 iterations of the report over time. There are, we submit, a number of objectionable features to that report and the circumstances. The first of which is that, having gotten to the stage that it had, one would have expected to have seen a draft of potential reasons for approval of this proposal. And the court can, if it wishes, look at any of the other decisions, and there haven't been many, but those that we could find that we've set out within the bundle. So, for example, there's the Kids and Coffee Hall report at page 136, Brittle Mill at 149, and Old Hall Church, at 159. And in relation to each of those, what will be seen is a very different structure to the report that occurs at the second stage of the process, where either reasons for approval are being expressly set out, or it's clear from the report that the author of the report understood that members had agreed that a proposal was acceptable for reasons that are set out in section 1 of the report, in the introduction of the report, on each occasion. So that is a fundamental omission, we say, from the report that was prepared in this case.
That all presupposes that the author of the report thought that the resolution was different from that which the judge held it to be. Because if the author of the report thought that nothing had been agreed in principle and it had all been parked, then you wouldn't see the start of the report being, we've agreed in, the committee has agreed in principle and therefore.
My lady, I accept that. To that extent, this part of the submission is parasitic on the earlier approach. But what I do nevertheless draw attention to, and bearing in mind all the caveats that the judge raised about reports being generated by different authors over a period of time, there is a measure of consistency to what was being done in all of these other reports. And it really is, I suggest, a fundamental inconsistency between what was being done in those other examples and what was being done here. And one of the issues in relation to that, and of course, my lady's been keen, and members of the court have been keen to try and get behind what defer might have meant in these circumstances, what members of the committee might have thought it meant on the second occasion, for example. Some of the correspondence, the internal correspondence, does give some insight into that. So if we look at Mr. Hopkins' Exhibit 2, which starts at page 172 of the supplemental bundle. We see the first email from Miss Dougal to Mr. Holmes, copying Sarah Hill Sanders, at this stage just about what the report might look like, and the first draft of the report is provided. But then more importantly, we submit in the next 2 pages, there are emails of the 17th of December and then 21st of December. 174 is the 17th of December from the chair of the committee to Mr. Holmes and Mr. Green, head of planning. I'm hoping to speak to Mike, and Mr. Hopkins explains that that's, to the best of our knowledge, one of the councillors, about the position officers will be taking over the Roxwell site. You mentioned needing a steer from the Lib Dem side, the present position being that you will be giving the reasons to approve as per our decision. So that is speaking to and understanding common to the chair of the planning committee and senior officers of the local planning authority. And it's referring to an understanding about giving reasons to approve. Again, our submission is that is only consistent with an in-principle decision having been made, which accepts that the first 3 reasons for refusal, and indeed the 4th, which the officer in the first report accepted, or during the committee debate accepted, would not stand alone. That they were overcome. And then 175, email from Keith Holmes to Mr. Green, copied to a councillor and the chair of the planning committee.
This is earlier.
This is the same councillor, presumably, that was referred to on 174 as the person they were hoping to speak to.
Yes, that's our understanding.
Yeah.
I'm right in thinking these are emails are in reverse chronological order. Or not? No.
No, it's confusing because they were sent through to us in.
Thank you.
Oh goodness, they're different times.
Yes.
My mistake.
Yeah.
So we're dealing in the first instance with the. I'm sorry, my lady.
17th of December.
Yes.
Now we're looking at the 21st of December. Yes. So look at the body of the email.
Yes.
Yeah.
And so we can see what's happened there, and these changes can be chased through in Mr. Hopkins' table. Is what I've done so far okay, or do you want something more overt needs to be finalised by a certain date, copied to councillors for comments. And one of the fundamental distinctions in relation to local authority decision making is officers advise, members decide. And what we say is that it is an indicator of a steer being provided in a particular way when reports are being changed, and part of the exercise that's occurring is that they're being sent to councillors to consider whether or not they have any further observations to make. Just two other emails in this batch that I will refer to for present purposes. Page 176 is an email from Councillor McCrory back to Mr Holmes, Mr Green, and again copied to the chair of the committee. Following my discussion with David today, we agreed that it would be made clearer to the committee that the original recommendation was still available to the committee if they were not satisfied with the reasons. Please discuss with David. Well, the reference there to reasons, we say, should be a reference to reasons for approval, consistent with the email that we have just looked at. So again, there's a further underlining of what ought to have been happening through the process. And what we have certainly not been shown at any stage through this process is any draft of the reasons for approval or any suggestion of where and how they drop out of the picture, having been referred to in at least two of these emails. And so in terms of looking at the overall picture that's created in the eye of a reasonable onlooker who sees all of this material, we say, when you put that together with the report and the other features that are mentioned, that what it creates is the impression of a process that is being driven in a particular direction. To reopen issues which, on the face of these emails, were thought at least to have received recognition, and the members having thought that they were capable of being overcome, hence the need to draft some reasons for approval.
Well, doesn't this run suggest that at least some of the people that this was circulated between thought that the original recommendation was still available, that you could go back to the recommendation to refuse, and so on and so forth, and that the contents of the report ought to make that clear. And although the original chair had said recommendation to accept initially, she seemed perfectly happy and was happy with the final draft. So all that was being said is, whatever you say, don't make it look as if you've closed the door on the possibility of going back.
Well, my lady, that's one side, as it were, of the coin of these emails. I say that the other side of the coin, which is perhaps no less important, are the references to there needing to be reasons for approval based on the idea that the deferral carried with it some form of substantive decision. Otherwise, why are those references there in both the senior officers, none of whom appear to contradict the importance or need for this provision, or indeed the councillors between whom this email is circulating?
My reaction to all of this is that one thing that the transcript shows is that, and this is not a criticism, it's just a fact, the people speaking and the people with whom we're dealing are not using the same precision of language as they would if they were lawyers trying to draw up a formal document. And I re-emphasise, I don't mean that as a criticism. This is lay councillors, with or without a degree of understanding, with or without a degree of training.
One probably makes allowance for those.
One certainly should.
Yes.
Even when one gets to the officer's report, as
even officers' reports, as the law tells us, are written by people that have a level of training, but they're not normally qualified as appellants, they don't express themselves with the same level of precision. But taking all of those points, I hope, fully on board, what the members of the committee were looking at on the first occasion, and what the tenor of the debate, we say, shows, is this relatively binary position in relation to an outline planning permission, where it's either refuse at that stage or think about whether or not the issues of principle have been overcome by what would be a welcome addition to the housing stock. And that...
I'm sorry to interrupt yet again, Mr. Beglam, but just so that I'm clear, in relation to these emails, are you alleging some actual impropriety, or are you just saying that it's an indication that by the time of the second meeting, minds have been made up?
Yeah, no, I should be clear about that. I'm not alleging.
No, well, that's what I thought, but I wanted to...
The case has never been put in that way. What I say is that there are a number of indicators which, read together, give the appearance to an onlooker who's neither unduly suspicious nor uninquiring about these things, as to how this matter was progressing. And therefore, senior officers and councillors referring to the apparent need for reasons for approval to at least be canvassed, to be present and appear within the second report, is important. It's one element of the overall package. And so, well, the last email that I wanted to draw attention to is page 179, and it's, as it were, simply a reinforcement that here we had again Mr. Holmes sending an email with the report out to various individuals with a further opportunity for comment or amendment in relation to that report, and insofar as it was going again to members for a second occasion, again we say that blurs in an inappropriate way, or would be seen by the reasonable onlooker to blur in an inappropriate way the clear distinction between officers who advise independently and impartially and the members who decide.
Well, are you saying that it's wrong in principle for the officers to seek assistance from the members as to what should go into their report?
Yes. And the submission goes one stage beyond that even if there may be some relatively neutral kinds of guidance that might be anodyne in this respect, that's not how this interchange would appear to a reasonable person.
How do you say it would appear to a reasonable person?
I say that this is one indicator of the decision-making process being driven in a particular direction. That's the appearance.
That's a bit vague and woolly with respect.
Being
driven in a particular position, in order to show somebody's made their minds up, you have to show that this exchange of emails is indicative of a particular mindset on the part of the decision makers. So where is it in this exchange that one draws an inference that people who were on the committee had made their minds up to refuse, or were looking at it with a check through a blinkered prism?
In relation to the members of the committee, it would only be the chair. The other sources are officers.
So what does it matter what they thought?
It matters because the chair governs the rules of procedure at a meeting. The chair is, my lady, I say we can see how it matters from looking at the transcript in this case of the second meeting, where the chair from the outset makes it very clear, referring to the earliest passages of the officer report, the second officer report, to say, I remind everyone that all options remain on the table in circumstances where we say the natural centre of gravity of that meeting ought to have been towards the acceptability of conditions. And
that again depends on ground one.
Yes, it does.
It does. I mean, it must do.
And
because you're not mounting a sort of freestanding attack on the reasons in the second report or anything like that.
And you think it's a bit strange if the chair made her mind up that the very first email in the chain that you show us is one where she's asking the planning officer to set out the reasons to approve.
My lady, no, because that was part of the process that ought to have been undertaken. What is more curious about that is that having been acknowledged, it then never happens.
But she wasn't the driving force behind that. Driving force behind that was another councillor who said, I think we need to make it more clear that all options are still on the table. And she said, OK, that's fine.
Yes, but in a sequence of emails where the chair of the planning committee, who presumably apprehends that they're going to have conduct of the second meeting, sees what is occurring, has to be taken to know from what's in the emails that in the normal course of things, reasons for approval, potential reasons for approval, ought to be being drafted.
But assume,
and that's not happening.
But assume for the purposes of argument only, and I'm not giving it any indication at all, assume for the purposes of argument that the chair came to the second meeting firmly resolved in her mind that this was an application that should be refused. How do you get from there to subvert the decision of the whole committee on the basis that its mind was closed?
We get from there on the basis of looking at the, back to ground one and ground two, but looking at the earlier decision, looking at the absence of any recognition of the importance of consistency, or to put it perhaps in lay people's terms, any real recognition of the importance of what colleagues had decided at the first meeting. And then a sequence of emails where senior officers and the chair of the planning committee, and I do say it's important that it's the chair of the
to which the members of the committee are not party.
They're not party. There's no evidence that any
There's
of
no
them's
evidence
copied
that they've
in.
seen them. There's no evidence to suggest anything, which is why I go back to my saying, assume that the chair comes into that meeting with what you would call a closed mind, and for these purposes I'm going to say firmly resolved that this should be refused. How do you get from there to subvert or to suggest that we should draw an inference, and the judge should have drawn an inference, that the 10-to-1 majority came with a closed mind? I just can't see how you get off the first step.
Well, my lord, I can't do, as it were, more than refer to the 12 features that are in the statement of facts and grounds. But I do say it's important to look at these things holistically.
Well, I'm trying to. And I'm speaking entirely for myself. I think that the exchange of emails is at least the suboptimal practice. I don't want to. I'm not made my mind up, but it doesn't look terribly good to me at the moment. But that's an awfully long way from subverting the whole of the process at the moment.
Well, the evidence is what it is.
You go back to the 12. Okay, thank you.
My lord, I'm grateful, and unless I can assist with any more questions, those are my submissions.
No, thank you very much indeed, Mr. Beglan. It's been very helpful. Yes, Mr. Cannon.
Well, I'm conscious of the time. Shall I make a start? And I'm probably not going to be able to do everything in 15 minutes, assuming that your lordship will want some lunch. I just mentioned it now. Whether
Yes. Why don't you make a start? Thank you.
Can I start then by mapping out what I'm proposing to say? First of all, insofar as is necessary, and I've finished out quite a lot of this, a quick tour of some of the documents that are important. Of course, my learned friend has taken your lordship's relation to some of those, just a couple more of those, so that won't take too long. And then I want to make some points of general application, the majority of which are not controversial, and then home in quickly as I can on the question at the centre of the appeal, which is the meaning of the resolution taken on the 3rd of November. And I accept and endorse the observations, I think, made by all of the bench today, that really the case, the appeal boils down to that point. So I'm going to hone in on that straight away. It seems to be on that which turns all three grounds. And in headline form, our submissions are that resolution was made in the context of the requirements of the Constitution, which were known, that the Constitution required deferral in the circumstances that arose, that the meaning of the resolution, subject to the point my lady Justice Andrews made about the admissibility of this sort of point at all, is not affected by differences between the resolution as recorded in the minutes and that recorded in the transcript. So our case is those differences are immaterial, whether or not that's arguable, and we remain neutral on the jurisdictional point. And that overall the learned judge was correct in paragraph 34 of her judgment about its meaning and effect. And then on ground 2, again in headline form, the consistency principle is not engaged on the facts of this case at all, adopting the learned judge's phraseology. It was inchoate decision making, and the principle doesn't attach to that. But if it was engaged, then it was discharged here. To adopt my own friend's language, the committee plainly did confront the fact that there had been a change of mind, collectively speaking, between the first and second meeting. And on ground 3, and I don't apprehend taking very long on ground 3, we essentially adopt, let me put it that way, because I think the judge adopted my submissions below, but we in turn adopt hers in finding that ground 3, which was ground 4 below, doesn't show closed lines. In fact, the facts show the opposite.
Right. Well, that's, if I may say so, a very, very helpful preface, Mr. Cannon. Shall we, given the time, shall we deal with your brief review of some relevant documents and general points, bringing us to a point of cheerful lack of controversy at that stage, and then we'll defer the more controversial submissions till after the adjournment.
I'll try and structure it that way, my lord, but we'll see how we get on. Okay. So first of all, the officer's report, only one point from the officer's report that I just want to show you.
The original report.
Yes, it's in the core bundle at page 165. I'm grateful, my lady. I'm going to say the officer's report when I mean the first report, and the further report when I mean the second report. That's the typology we've used in our skeleton argument.
Yes.
But I'm happy to be called up on that if I don't.
Fine.
Apart from that.
So page 165.
Indeed, that's the officer's report. At the back of it, and this is the only document that we haven't looked at yet of any relevance, is the plan. I just want to make a couple of points about the plan. They're not controversial, they're factual points. And you can see the red line, which is the area to which the planning application related. And it's said elsewhere in the officer's report that part of the rural employment site or zone. It's broadly, it's half. So half of it was allocated in the plan as a rural employment site and was in active employment use as recorded in the officer's report. And the other half of it, in fact a bit less than half, is denoted in the local plan as being what the local plan calls countryside, essentially greenfield, undeveloped land. And broadly speaking, that's the land to the north and east. Some to the south, but largely in the protrusion to the north and east. And of course, just to draw all those together, it's in that zone, that area in the north and east, that the unlawful uses to which the enforcement notice was directed were taking place. So the position was that its planning status was greenfield.
Where it says recycling business.
Yes, exactly. The detail perhaps doesn't matter. In fact, it's east of there. There's a contour, what might be a contour line, a reverse L shape that surrounds the words recycling business, and east of that line is the countryside element. Again, broadly speaking, this isn't in evidence, and I'm anxious not to make too much of the detail, but I think it's uncontroversial. The point I want to make is that around half, it's a bit less than half, of the site was greenfield countryside land. The reasons which will become apparent in due course, this is perhaps tangentially important, and half of it was the rural employment site which the local plan sought to protect. I keep saying about half, in fact it's 4.73 acres employment and 3.96 acres greenfield countryside. The next stop on the tour of documents is the minutes of the first meeting. They're on page 18. Start on page 18 of the core bundle. I only go here in the light of a comment made by my lady Andrews, of course, of her friend submissions. The minutes record on page 20, the resolution, and we'll come back to it. And just as a matter of fact, uncontroversial fact, although I think not in evidence.
I think we're in the supplementary bundle.
Yes, it's the supplementary.
Forgive me, it is, of course. Did I say core?
Yes.
You did.
In hindsight, putting them both in one lever arch is probably not a good idea on my part. I shall deal with that decision.
Okay. We're on page 20.
Yes, the resolution, about halfway down the page, resolved that. The point is only this. My lady said in the course of my own friend submissions that there could have been some comment that wasn't accurately recording what was in fact recorded. Well, in fact, those minutes were formally approved, as minutes are at the next meeting in December. Now, that's not in evidence, but again, not controversial. As a matter of governance, they are the approved version of the minutes of that meeting.
Did anybody make anything incidentally of the preamble before the resolution? Because it says, after votes on motions either to refuse the application or to defer its consideration, to enable the condition to be presented on any grant of planning permission.
Did anyone make anything of that at the meeting or in this case?
Well, did anybody make anything of it in this case?
No. Obviously, my learned friend makes a point about the word any,
Yeah.
which I'm going to come back to.
But doesn't that actually reflect what's in the transcript?
Yes. Well, the word any features in the minutes version of the resolution. My learned friend's point
it should be
it's
a
rather than any in Councillor Raper's motion. Yeah. But there is internal consistency in this sense, and the only point I make is that those were approved without anything being said
it might be said against you.
Yes.
That the way it's recorded here is that there was a choice between a motion to refuse the application
Yes.
or to defer its consideration, which rather suggests that it hasn't been refused.
Yes, but I think that's right, my lady.
Well, it hadn't been refused.
It hadn't been refused. Quite. The choice at the first meeting, certainly ex hypothese on our case, is that either the officer's recommendation was followed, which would have meant a refusal of planning permission, or it's deferred. There's no other possibility.
Sorry, I expressed myself infelicitously. It might be said against you that leave it be. I'll keep quiet. Sorry.
My lady, please, if there is a point that will be said against me, I'll come to it when I can. And can I just pick up slightly cheekily on a further point about this difference of wording, but be clear that it's not a point that we've taken, jurisdictional point I've described it. In fact, the appellant's statement of facts and grounds in the initial claim, which starts on page 144 of the core bundle, say at paragraph 15 on page 147, and this is in the factual background, effectively, after the debate, by a series of votes, the committee ultimately decided, 86 with an abstention, as follows, the first decision, and then quotes the resolution from the minutes, not from Councillor Roper. So if there's any question, I think gracious enough to accept that he didn't put it that way, but in fact he put it quite the other way, that the resolution was that shown in the minutes, and in fact it was my submission below, for what it's worth, that the authorities provided that was an end to any questions of what the resolution was, because one looks at the minutes. And I apprehend that was accepted by the learned judge. I certainly don't see any dissent from that. But anyway, as I say, I don't take the jurisdictional point that they're not able to argue it, and clearly the Lordship have heard arguments on it. Just while we're on those differences, and just for completeness, I think there are three, none of which are material. And I don't know whether it's worth having one or both open, but shall I just map them out and then? So first of all, in the motion as recorded in the transcript, Councillor Roper says minded to grant, whereas in the resolution in the minutes
Minded to
minded to approve. And I pause to say that I say that's wholly immaterial. Second difference is that in Councillor Roper's motion as recorded in the transcript, he says further consideration be now deferred, and in the resolution it says defer it. Again, I say wholly immaterial difference. They mean exactly the same thing. And then the third, and I think my friend's favourite difference, so that officers may, this is Councillor Roper, so that officers may consider appropriate conditions to be imposed on a grant of planning application. Pause to say that's obviously a slip of the pen, or tongue as it means permission, and report back to a future meeting. Whereas the minutes say to enable officers to report to a future meeting on conditions that could be attached to any grant of planning. And again, headline response I'll return to it is that that difference is not a material difference in this context. Either formulation makes clear that the committee was seeking to follow what the Constitution required of it in those circumstances. And that is essential context when asking the question, what does the motion mean? Then the transcript, again, I hope very swiftly. I realise sense that I'm transgressing on my time limit for this. The transcript of the first week's, which is page 21 of the supplementary bundle. I think your Lordship's going to have this point. There's an initial attempt to put forward a motion, which is at 47. Top of 47. And just to make things really interesting, in that formulation, Councillor Roper says on the grant of this plan application. It doesn't repeat that when it comes around to it. But that motion, for what it's worth, is not passed. In fact, it's refused, rejected, not carried on the casting vote of Councillor Sozit, the chair. So nothing turns up. And the reason I raise that is that that's essential context for what Mr. Mayfield, the officer, says at 48. My own friend drew attention to. Where he says, members, just to be clear, the motion from Councillor Roper is to approve the application, and that if it is approved, it be brought back to a further meeting to decide the conditions to be attached to any planning permission. Now, I say up front that's wrong, but it doesn't matter because that motion is not carried.
Yeah.
There's then some confusion, and as we saw, the legal advisor, Ms. Marsh, intervenes at 66, page 66. And she says we should talk about whether we're wanting to refuse or approve, and I endorse the observation that that's in line with the Constitutional Commission, unsurprisingly for a legal advisor. That's 3/4 of the way down page 66. Then at 70, Mr. Holmes, also an officer, has a go at clarifying the position. Caveat that he's not a legal advisor, but he says this. But the fact that the officer, this is halfway down 70, the fact that the officer recommendation was voted against doesn't in itself take us anywhere, because it just means we don't have a resolution that has been voted in favour. That's the first point. And then a little bit further down, he says, bearing in mind, bottom of the page, bearing in mind that if there's a vote against the officer recommendation and in support of Councillor Roper's recommendation in whatever form, then the effect, that is going to defer the application to a subsequent meeting of the committee. It won't refuse it, and I pause to acknowledge the confusing nature of using refuse there.
Yeah.
As you know, from the Code of Conduct, now pause there to say, Code of Conduct has nothing to do with this, but the Constitution is called the Code of Good Practice. One can see that from page 15 of the core bundle, no, supplementary bundle. The title, Planning Code of Good Practice, which is what 5.2.7.1 is part of. And then he goes on to say what we've looked at already, because the committee can't make an actual decision to refuse it, again, unhelpful use of refuse, on the night.
Well, I think he means grant.
Well, he does, but my then friend said, and he may well be right, that he used negative language there because it would be a rejection of the officer's recommendation. Now, that might be the explanation. It would have been much more helpful if he used the word grant. But either way, the substance of what he meant is perfectly clear in that sense.
Can't make a positive decision to go ahead.
Exactly so. And then, just to draw that all together, at 77, Councillor Roper's revised motion, or second motion having been passed, Councillor Sozin, the chair, says, about little more than halfway down page 77, thank you. So this will return next time, conditions and further information, and to determine the reasons. Thank you. Is there anything else anyone wants to say? Next point, swift one, which is the further report. Now, I'm skipping over the exchange of correspondence. I'm going to come back to that perhaps after the lunch adjournment.
Yes.
The further report, which is on page 156 of the core bundle, just picking up on my lady's point about nobody murder, which actually is our point, but put forward by my lady this morning. So the further report is produced well in advance of the second meeting. It says, perhaps famously, all options are available to the committee at the top of 157. Paragraph 1.1, under the Council's constitution, second sentence in 1.1, first sentence, the planning committee has not yet made a formal decision on the application, and all options are available to the committee subject to the normal voting procedures. And not a soul says, hang on a minute, that wasn't what we understood we were doing on the 3rd of November. It also, while we're here, sets out section 4 on page 158.
You mean page 158?
Yeah, core bundle.
Oh, sorry.
Core 158. Forgive me,
Sorry.
I probably said it wrong.
Paragraph. Section 4.
Section 4, which is on page 158.
Yeah.
Just the observation that the report does set out a number of conditions to which any grant could be made subject.
Is that a convenient point to break off?
Yes.
Mr. Cannon. Thank you very much. Well, we'll resume at 2:15. Thank you very much.